So Andrew Langer, welcome to Constituting America's Constitutional Chats podcast. And
sorry, go ahead.
Just if you could start by telling us a little bit about Article 2 and the executive branch, and then we'll go to some questions.
And it's funny, I was trying to figure out the other day how many essays I'd written for Constituting America. I'm glad that the count is somewhere around 40. So that's good to know. This is really a fun topic for me because I do spend most of my professional world looking at what's happening in the federal executive branch and things that happen under Article 2. I was unique when I was lobbying at NFIB, the National Federation of Independent Business, because I'd had no Hill experience, which most of their lobbyists had. All of my experience had to do with those executive branch agencies. So, as we all know, and we've been talking about, Article 1 is Article 1 because the wellspring of all of the power the federal government is supposed to come out of the legislative branch. But then it's up to the executive branch to interpret and enforce those laws. We'll get into that in a moment. Article 2 is fairly straightforward. It starts with laying out how the president gets elected and the issues of electors. I know that's a source of great discussion and debate in America today, and we can talk about that if you want to ask some questions later on about it. The president is also commander-in-chief of the military. And let me say, that's the other part of this that I'm sure we've been going through with this countdown to Constitution Day, is the understanding and recognition that with the beauty of our Constitution is that power is diffused among several branches, and it's also checked and highly limited, and each branch gets their powers laid out. But with the issue of powers being checked, the president is, of course, commander-in-chief of the military under Article 2, but only Congress can declare war. Now, there's lots of debate over just what that means in modern parlance, and again, we can talk about that, but it's one example of how the president's power gets checked. Then the president serves in an advise and consenting capacity with the Congress in terms of appointments. Whether it is appointments to the federal judiciary, including the United States Supreme Court, but also the appointments to lead the various cabinet level agencies. We're going to talk in a moment about those agencies and just what that means. But senior executive branch officials, the president nominates them, but then Congress approves them. The president also is the person or the executive branch is where treaties and relations with foreign powers are really defined. The founders wanted the United States to speak with only one voice, understanding that Congress can speak with many voices, given both branches. That in terms of what happens once we leave the shores of the United States, it should be the president and the executive branch that negotiates those treaties, again, with those treaties then being ratified by the United States Senate. And again, lots of debate and discussion over things that don't quite rise to the level of treaties. Article 2 also lays out at the end how someone gets removed from office, including the president of the United States. And we've seen that in recent years play out, the circumstances by which a president is supposed to be removed. But probably most important, a very small phrase in Article 2 is that it is up to the executive branch to faithfully execute the laws of the United States. Those are the laws that are passed by Congress, the statutes that are passed by Congress. So the way it works is that Congress passes a law, and then it is left to the executive branch to interpret and enforce those laws. Congress has no real power in that regard. I mean, they have the power of the purse. But in terms of the day-to-day execution and enforcement of the statutes that Congress passes, it's left to the executive branch to do that. How do they do that? That's what we're going to get into. It is the issue of the agencies. Now, there are 15 cabinet level agencies, 15 cabinet secretaries. Those tend to be considered the most important because the heads of those agencies are the ones that are in line for succession in case something happens to the president. The president gets removed from office or the president becomes incapacitated. But beyond those 15 cabinet secretaries, there are anywhere, depending on who you talk to, and they're defined in different ways, anywhere between about 320 and approaching 450 federal agencies offices within the federal government, or entities within the federal government that create the rules and regulations that are spawned out of those congressional laws. They're the ones who are responsible for faithfully executing the laws. And let me give you an example by this, and then we'll get into this. We'll get into the issues of deference and sort of vagueness and how folks can get involved. So let's say that Congress passes the Clean Water Act in 1972, right? So under Article 1, Congress recognizes that there is a problem with water pollution in America. They pass the Clean Water Act, and the Clean Water Act says you cannot pollute a navigable water of the United States. And they authorize both the United States EPA and strangely enough, the U.S. Army Corps of Engineers to enforce that law. So that's how that works. So it goes over to the executive branch, and then those executive branch agencies become responsible for then interpreting what all of those words mean. So the word navigable is open to interpretation. The word water of the United States is open to interpretation. What it means to be pollution is open to interpretation. And so it's left to those agencies and the personnel within them to then define those terms and create the regulations by which the Americans have to follow them. And as you can imagine, over the course of the now 50 years of the Clean Water Act, those definitions have changed over time. Most especially and importantly, the definition of what a navigable water of the United States is. And again, I'm happy to take questions on this. And so that's essentially how you get a law that was designed to deal with rivers catching on fire, an important public policy concern, a river catching on fire in, say, Ohio, to eventually the regulation of wetlands across the United States, and something that is not per se navigable because of interpretations, they become navigable. And one of the problems that occurs is the more vague a term is in statute, the more open to interpretation that wording can be by the agencies. We can talk about the relative merits and why Congress passes legislation with vague language, but in the end, it really doesn't matter the why. What matters is the impact, and what that means is that the agencies can then change their definitions over time, so that a word that had a meaning in one way in 1972 would have a very different meaning in 2022, and it opens up huge, enormous amounts of power. Now, that power is checked by Congress. It can be. Congress can turn around and define those terms explicitly in statute. We want them to do it. But otherwise, the agencies have what is called deference. Their interpretations are deferred. And there are two different ways that agencies get this deference. We don't have to get into the specifics there. Suffice it to say that pretty much how an agency interprets the regulations, if there can be a legitimate interpretation made, courts will uphold that interpretation. We'll get into the challenges in a minute. What happened very recently, just so you all understand this, is that these questions of interpretation came up in a very recent Supreme Court decision called West Virginia versus EPA. And there was some talk that the Supreme Court was going to sharply rein in how the powers, the deferential powers that these agencies have. Now, the High Court didn't go quite that far, but the High Court did say that when it comes to major questions, these executive branch agencies cannot take relatively innocuous language and then answer or try to make major changes to the law. It's called the major questions doctrine. What do I mean by this? What I mean is that if Congress passed a law that says that businesses have to maintain clean workplaces, right? A workplace cleanliness statute. The executive branch, the president and the executive branch cannot turn around and use that to create, let's say, a national vaccine mandate. That they can't shoehorn big ticket, big decisions, sweeping decisions into small amounts of language, or as was the issue in West Virginia versus EPA, use air pollution statutes to completely remake America's energy sector. That's a big deal that Congress would really need to weigh in and declare that that was their intention by this statute. Now, but there, we want people to get involved, so it doesn't just sort of end. An agency can't turn around and simply say, "This is what we're going to do." Let me rephrase that, because we're going to talk about executive orders and other kinds of documentation in a second. But when it comes to the regulatory process, the big ticket regulations, let's say the agency wants to define what a navigable water of the United States is under the Clean Water Act. I know I keep harping on this, but it's because it's an issue that's gone back and forth over the course of many years, and so it's a good example to use. What happens is that the agency, under a law called the Administrative Procedure Act, passed by Congress in the 50s, there are a series of steps that the agencies have to take in order to follow the law and make sure that they're not abusing their power. So essentially, an agency has to put out a proposal as to how they're going to be interpreting what Congress said. They have to open it up for comment over a significant period of time. They have to let the people actually comment on them. And it's never been easier than it is now to get involved and comment on what these agencies are doing. And then what's best about it is that when the agency reviews all of the comments that it gets, if you filed something that is substantive in nature, I'll explain in a moment what that means, then the agency is required to respond when they put out their final decision on the rule, on the regulation. And I use the terms rules and regulations interchangeably. They're the same thing. The agency has to explain either why that they adopted a change based upon your substantive comment, or explain why they didn't make the change. Otherwise, they open it up to be challenged. And what do I mean by substantive? What I mean is you make a comment that actually raises a substantial point, that isn't just echoing something that somebody else said. A lot of times, a lot of groups, and I've done this, I'll be honest about this, will try to engage in a form of referendum or plebiscite on a regulation by trying to put as many identical comments or nearly identical comments into the docket. While that has a place politically, from a substantive perspective, it doesn't add anything. If 15,000 people send in a postcard or an email to an agency saying this stinks, it may it may reflect that there is some sentiment out there. But unless somebody says something that is substantial in nature, the agencies don't have to respond. And so, again, talking about the checks and balances, and you can then challenge an agency's final rule, right? So let's say, I'll give you an example, real quick example. Way back when, despite the fact that Congress had said that farming activities were exempt from the Clean Water Act, a few years ago, somebody at the EPA put forth an interpretation of the Clean Water Act. The Clean Water Act, you can regulate runoff from mountain ranges. So somebody proposed that maybe they declare farm furrows as mini mountain ranges, therefore subject to the Clean Water Act's jurisdiction. So if you had commented on that and said, you can't do that, that goes against what the express legislative intent was, the EPA has to respond to it. And if the EPA didn't respond and still went ahead with their change, then the rule can be challenged in federal court. And that's the way it works. It takes many years, but the only way you can challenge a final rule is if you had commented on it before. So it behooves people to get involved in these things, even if they're not going to, even if they're not going to, they don't think they're going to challenge it. But there's a whole nother issue that's out there. And this is part of the problem, and I'll sort of sum up here and open it up to questions therein. So there is this process, the Administrative Procedure Act, but that only applies to actual rulemakings. Now, there are plenty of rulemakings that are out there, plenty of regulatory proceedings. If you go and you visit regulations.gov, you'll see that there are literally thousands of these kinds of proceedings that are happening at any particular time. One of the things that we're doing in the Institute for Regulatory Analysis and Engagement is looking at that. Anyway, But short of that, there are things that are quasi rulemaking in nature. Agencies will put out what are called interpretation letters or guidance documents that they try to put out with the force of law, but haven't gone through the same kind of vetting. And of course, the president can issue executive orders on things. And every president does, and it seems to be getting increasing over time that more and more presidents are doing things. And what these executive orders do is they change the way that the executive branch operates, and can massively change the direction of regulations or how the law gets enforced. But of course, there's no permanence there because they can be undone by the next president. So, for instance, you have a president who comes in and says, we're going to be more transparent when it comes to guidance documents and interpretation letters, and more transparent about administrative proceedings. Take 30 seconds on this. A lot of these agencies that are in charge of enforcing regulations, they also have administrative law powers. So they're not the judicial branch. They're not law enforcement in the same way that the district courts are, but they have law enforcement powers, and they can also act as the judiciary in adjudicating complaints against people. And a lot of times people feel that they get caught in a star chamber kind of a situation. So you have one president that comes in and wants to rein that in, then another president can come in and get rid of that and get rid of transparency in that regard, as has happened. And that's a huge issue. Our friends at the Competitive Enterprise Institute, my colleague Wayne Cruz, refers to these kinds of things as regulatory dark matter. They add to burden, and I know we're going to get into burden in a few minutes, but so that's it in a nutshell. Congress passes laws under Article 1. Those laws go over to the executive branch. The executive branch is responsible for interpreting and enforcing those laws. They will faithfully execute the laws. They do that through the regulatory process, and there are whole ways that they go about doing that, as we've said. But I've gone a little bit over the 12 minutes, Kathy. I'm sorry about that, but I think we can now open it up to discussion.
Well, you've said a lot and given a great overview of Article 2. Thank you so much. And I think we want to go to Janine.
Hi,
Hello,
everybody. Janine. Welcome to the show. Hello, Andrew. How are you?
I'm good. Looking forward. I'm hoping I'm going to see you when I come up to New York this fall.
I would love that. Good. Love that. Okay, so now, well, that was an amazing overview. And I think I always love to compare things in regard to my questions to two things. One is today, and the other is what would our founders have thought about all of this? And the complexity with which you briefly explained quite wonderfully the Article 1, but it's so incredibly complex in modern day. And I would wonder, my question to you is, what would our founding fathers think about this? Because it's so out of control with the people actually having a say in what's going on, understanding what's going on with the bills that are so big and the regulatory agencies and things of that nature. It's just so far away from the people. And I just wonder what you think. My twofold question, and I want to move on because I make it kind of short because I want to make sure everybody gets enough time, please. Sure. But the twofold question is, is this really what our founding fathers envisioned, number one? And number two, what's to be done about the fact that the American people feel really, if they're paying attention, such a loss to what liberty really means, and that now if we can't understand what's going on, if the laws are so voluminous that they cannot be read, or so incoherent that they cannot be understood, just James Madison, paraphrasing, what's the point of having laws or having a government at all? So those are my two questions.
And that's exactly it, right? I mean, it's an issue of, the founding fathers would really not recognize a lot of what the federal government does today. And again, the interplay. I mean, let's not even talk about regulations for a second. Let's talk about the issue of Congress being under their Article 1 power, being the only ones to be able to declare war. And yet we have an environment in which, the president can send American troops or American military forces overseas to engage in warfare without congressional approval, and the president has to report back on it and can sort of extend this ad infinitum. That's certainly not what the founders intended. But certainly the founders never intended for there to be anywhere between 320 and 450 executive branch agencies, with the federal government sort of, getting involved in so much stuff. It's funny, when I was teaching, one of the very first things I would have my students do is I would have them go through, there's a really great website called regulations.gov. I love it. It's a great resource. It's the best way for you to go and get involved in the rulemaking process. But they have a little portal on the side down in the lower right-hand corner, proposals that have come open for comment in the last week, and proposals that are closing in the next 7 days. And I would have them go through each of those and to pull out just something that caught their fancy. And the idea was to and then I would go and list them on the whiteboard, the PowerPoint. And the idea was to have them understand the breadth of everything that the executive branch is involved in, right? Whether or not it is soliciting comments on reforms to the Endangered Species Act, right? And we might be able to make a case that, that there's a role for the federal government to be protecting endangered species. At the same time, the executive branch is soliciting comment on the schedule of drawbridge openings on drawbridges on the Intercoastal Waterway in Florida. And so it's just sort of the two extremes there that are at work. So there really isn't they certainly wouldn't have recognized a lot of this. And some of this has to do with the massive expansion. I mean, obviously the powers of the federal government have expanded over time. Certainly, in the 19th century, there was a certain level of expansion. And then in the wake of the Great Depression, there was an even greater acceleration of that expansion. Between the 1930s, I was just telling my daughter the other day, between the 1930s and the mid 1990s, under a very wide interpretation of the Commerce Clause, right? The federal government has the power to regulate interstate commerce. A lot of power was given over to federal regulators in the name of regulating interstate commerce. And it was really only the 1990s where the Supreme Court finally said, you know something? This was never intended. This is never what the founders wanted to do when they started to rein in executive branch power under the Commerce Clause. I'll give you a real quick concrete example. Again, under the Clean Water Act, because I spent a lot of time thinking about this. Navigable waterways were redefined to essentially include what are called wetlands, which are patches of land that don't have to be wet all the time. And finally, one of the Supreme Court justices, I don't remember who offhand, in a case talking about the limitations of the Clean Water Act, wanted to know why this was possible, why this was possible under the Commerce Clause. And the person arguing in favor of this expansive power said, well, maybe a goose will fly overhead and will glance down and see an isolated wetland in somebody's backyard and want to land there. And because the goose is traveling in interstate commerce, therefore, that's the federal nexus to regulate this. And it's called the glancing goose theory. And again, I don't think James Madison or Thomas Jefferson, I wouldn't do anything. Alexander Hamilton would say, oh, you know something? Yeah, because geese glance down. That's why a pond in my backyard gets to be regulated by the federal government.
No, sorry, I was sneezing. I couldn't get on. No, that's fantastic. I just want to move it on. Thank you so much.
Thank you,
everybody. I mean, I would go back and forth, but I need to be fair.
Well, Tova, we're going to toss it to you.
Great. Well, thank you so much for being on. And I thought you gave a really great overview of the second article. But I was curious if you could talk a bit about executive orders.
Sure.
What the basis for that is in the Constitution, how that's checked, if at all, and sort of how that power has developed over time.
Right. And so, it's an implied power that within the powers of the powers of the executive branch to faithfully execute the laws of the United States, that the president and therefore the president as the chief executive of the executive branch has wide leeway in terms of how that executive branch gets managed, right, within the confines of the law. And so because elections matter, and because, the heads of these agencies can change hands when a new administration comes in, part of the way that the presidency exercises that change in power is through executive orders, sort of the unilateral decisions that have to be, obviously they can't be unlawful. So the president can't all of a sudden declare something that Congress has done and do the opposite of it. But within the confines of statute, the president can make declarations about the way that the executive branch is being managed, and how they're going to approach public policy decision making. So, for instance, again, you have a situation in which I'll give you, I won't refer to the president, but I'll just refer to the circumstances. So you have a president who comes in, and the president wants to rein in the expansive use of regulation. And more to the point, folks who want to get around the regulatory process by trying to regulate through what we were talking about before, these guidance documents and interpretation letters. And what do I mean by that? I mean that agencies will create guidance, internal guidance for how they're going to approach a regulatory issue. It's not the regulation itself, but just how they're going to approach regulating. And therefore it has a huge sweeping impact. And so one president comes in and says, something, I don't like the way that agencies have been using these guidance documents and interpretation letters as a way of getting around the Administrative Procedure Act. Therefore, we are going to subject them to a much higher standard. And this will complicate the regulatory process, but we want a regulatory process that is deliberative in nature because A, it will protect people's rights better, and B, it prevents agencies from sort of engaging in the massive misinterpretation or reinterpretation of the law. So a president does that. The next president comes in and says, something, I don't like the way that this prior executive order has made it more difficult to make changes to the law that are more streamlined and easier to do. Therefore, I'm going to sign another executive order that gets rid of the prior executive orders. And so that's the way it works. Essentially, what happens is, so there are executive orders like that. There are executive orders that essentially say, I want an agency to go and re-examine a particular interpretation in the rulemaking and then open up a rulemaking process. So it's essentially the way that the administration or the White House itself guides these agencies. And we haven't even gotten into this, which is you have a White House, right? That's the executive office of the president. The colloquial term is the White House. And then, of course, as we said, there are all of these agencies that operate under it. Now, all of these agencies are also managed, and their operations are managed by something called the Office of Management and Budget. So all of these rulemakings and, frankly, the interpretations and guidance documents, they're all supposed to be approved and reviewed by folks within the White House and therefore within the Office of Management and Budget. And so that's a whole process in and of itself. It lends to the deliberation, but it also means that reforms might have more problems. Anyway, there's a whole bunch of things that go along with that.
Hold
on. Let me add something real quick, Tova, because you asked about checking this. As always, the executive branch is checked by the other two branches of government. It's much more difficult to check an executive order through the courts for a whole host of reasons. But usually, if Congress and, frankly, the opposing party, if they're in control of Congress, if they don't like something that the president has done through an executive order, then it is always up to Congress to act either by passing a statute that sort of deals with what the president did in executive order, or by engaging in the power of the purse strings and making it impossible for the executive branch to fund whatever has been done through that executive order. Sorry.
Thank you.
You're welcome.
No, that was a great addition. and you're the expert, so thank you for adding that.
No, thanks. Good question.
Thank you. And then looking towards the impeachment process, I was reading through the second article, and that's at the end, it describes, the ability of Congress to remove, president, vice president, and all civil officers of the United States for the conviction of treason, bribery, or other high crimes and misdemeanors.
Yes.
So would you be able to talk a bit about the impeachment process? And I'm just curious, I guess, looking at it from a historical perspective, it really intrigues me how the founding fathers sort of came up with this idea or this process of the executive being removed, because they came from a monarchy, and I doubt that you could just remove a monarch if you didn't like them.
So you'd have to have a revolution. Yeah.
Right.
Yeah, you have to have a revolution, and that's just it. It's and again, it is interesting. Now, I will admit, I'm not an expert on the impeachment process, but I do recommend that for folks who are really interested in impeachment issues, if you don't read the work of a professor from George Washington named Jonathan Turley, I highly recommend reading Professor Turley's work, jonathanturley.org, I think it is. And he writes about all of these things. In fact, part of my concern about the problems of expansive executive branch power and a skepticism of expansive executive branch power come from the writings of Jonathan Turley. It's someone I met very early on in my career 25 years ago and have had respect for him ever since. The point is, the impeachment process was truly supposed to be for a president, a vice president, somebody who committed a truly heinous act while in office. It was not supposed to be done for political purposes or to score political hit points, either in elections or just to blunt the presidency. But this issue of truly high crimes and misdemeanors. And what that means is, they don't mean misdemeanors in the sense of the way we look at misdemeanors and felonies, in other aspects of the law, but sort of the high level transgressions. What they wanted to do was, if you discovered that the president was a crook, or that the president knew that members of his family or her family were crooks and they didn't take action, that they were abusing the power of their office, and enriching themselves as a result, or undercutting the United States militarily or the national security of the United States, then that person, there should be a mechanism to remove that person, and remove that person peacefully. The peaceful transfer of power was very important to our founding fathers. And that's why, for many, many years, the issue of impeachment or the mechanism of impeachment was used very sparingly, and not for essentially political purposes, as I fear that down the road it may become, as the pendulum keeps swinging. We don't want that. But what we do want, and we want to make sure, is that elected officials and other civil officers are held accountable. So, for instance, if it is discovered that, let's say, a Secretary of State of the United States. So you have the president, you have the vice president. The third most important cabinet official is the Secretary of State of the United States. The person who is supposed to represent the face of the United States with, in front of foreign powers, supposed to do that negotiation. If it is discovered that senior personnel in the Secretary of State's office are also taking money, working for an outside consulting firm, I'll use the modern parlance, while at the same time, the spouse of the Secretary of State runs a foundation that is getting money from people who have business with both that consulting firm and the State Department itself, one would hope that there would be some kind of an investigation into that. And there is this mechanism for impeachment that allows for that person to be removed from office. That's why it's there. Essentially, in instances where these high-level officials are abusing the public trust, we need a mechanism to remove them peaceably from office.
Thank you so much. And then my final question, before I'll pass it on. Last week, we had a really fascinating discussion. We were talking about the legislative branch.
Yep.
We were talking about the differences between the legislative branch on the national level and on the state level.
Yep.
So I was curious if you had any knowledge or could speak to the differences in the executive power on the national level, and then maybe how individual states have decided to create that system and balance that power.
A lot of them sort of replicate in many ways how the federal government does it. Different states do it better in terms of how you engage in the regulatory process. There's been there has been a move over, frankly, the last 20 years to engage in substantial amounts of regulatory reform. Because as vast as the federal regulatory state is, and I may talk about that in a moment, and it is vast, states also, and depending on where you are, and I'll some of our bigger states can have larger regulatory regimes, and that hampers the ability of, for instance, businesses to do business. A lot of what's called red tape, prevents businesses from moving forward. And so in the last 20 years, because of organizations like the National Federation of Independent Business, and frankly, because of the efforts of a lot of organizations that are out there, there have been efforts to engage in regulatory reform in the same way that there have been efforts to engage in regulatory reform at the federal level. So I'll give you an example. In the 1990s, in an era where there was, frankly, more cooperation, you had a Democratic president and a Republican Congress. There was a real move to engage in some legislative regulatory reform. And so one of the laws that was passed is the Small Business Regulatory Enforcement Flexibility Act, SBREFA. And what SBREFA says is that when agencies are considering regulatory options, they have to measure the impact on small business, because small businesses deal with regulations differently than big businesses. And so and this thing called the Paperwork Reduction Act, which also aims to reduce the amount of paperwork that these businesses have to engage in. And SBREFA has been a real success. And I could get into that if you want. We don't need to. The point is, to get to your question, Tova, is that a lot of states have adopted similar versions of SBREFA, the Small Business Regulatory Enforcement Fairness Act, as a way of helping these small businesses. And to some extent, cities have as well. Just to make it easier to reduce those regulatory impacts that are out there. One of the other problems we find, by the way, real quick, is the issue of, I don't know if you guys talked about unfunded mandates, but a lot of times what the federal government will do is they will pass laws, but they will leave the enforcement of those laws or the regulations that are within them up to the states to deal with. So under, for instance, the Clean Air Act, states are responsible for creating what are called state implementation plans for how they're going to deal with air pollution in their midst. And those plans change over time. And a lot of times what will happen is that the federal government and Congress and the executive branch will tie grant monies to these states for dealing with them, right? If you don't follow this, you choose not to enforce the Clean Air Act or what have you, then we won't give you grant monies. One of the famous examples is Congress couldn't pass a nationwide 55-mile-an-hour speed limit in the 1970s. Was one of the ways that we were going to save gas in America. So what they did was they made federal highway monies, right? So Congress gives money to the Federal Highway Administration to dole out to states to fix their highways. Well, the Congress and the executive branch made those grant monies contingent upon these states passing 55-mile-an-hour speed limits. Finally, some states got fed up with it. Citizens in those states like, something, forget it. We'll fund our own highways. We just wanted to be able to move our people to and from without them having to, deal with it. And that sort of opened up the door to many, many states. In fact, I don't think that there is any state now that maintains a 55-mile-an-hour speed limit on their major highways. But that was just a moment of personal privilege. I grew up in New York. I went to college in Virginia. It would take me 7 to 8 hours to drive home or to drive from home down to my college in Virginia when it was a 55-mile-an-hour speed limit. Now it takes me just around 6 hours to get from where I am because of changes to that law.
That is great. And a great question, Tova. I mean, states are laboratories of democracy.
Absolutely.
And they've come up with some very innovative ideas for sure. Well, I want to make sure we get to Jewel and Jorn, and we still want to get to some audience questions. So Jewel and Jorn?
Yes. So we've been talking about, sometimes we end up getting back to this concept of the legislators make the law, the executive branch enforces the law. the executive branch seems to go too far compared to the founding's vision. And the answers oftentimes revolve something around that the world just got very complicated, and there's been so much industry and so much advancement. And while that's not an unreasonable thing to say at all, it also kind of pairs down a big question to a little question. And I think it cuts out a lot of interesting analysis that we could make. Because I think one big difference is the question of, it makes sense that it makes sense if we're looking just for efficiency, that legislators allow an agency to enforce and interpret a law that they pass so that they don't have to necessarily.
Yeah, right.
But at the same time, I think that's a major question of that. Well, whether we think it works or it's efficient or not, is that the way the government was built to work.
Right. And the issue comes down to really, the beauty of the constitutional structure is that it's very elegant in that it allows for adaptability, right? While at the same time making sure that individual rights are protected to the greatest extent possible. The issue, really is if you are no longer an adherent to those constitutional precepts, that's when you sort of get to where we are, which is a federal government that has its fingers in sort of every aspect of daily life. That's certainly not what the founders intended. Should the federal government be enunciating standards for how long it takes dishwashers to dry dishes, or what kind of toilet I should be putting in my bathrooms in my home? Whether or not I want to. Anyway, I won't bore people with all of that. And I know I keep coming back to the environmental issues because those tend to be the thorniest and also the ones that I've most dealt with. Should Congress be passing a federal minimum wage, right? I mean, should it be left to the states to decide how this is done? Why is it up to the Congress to do this? So these are all these kinds of questions that are out there and get asked.
I wonder if you take something like the Clean Water Act.
Yeah.
Okay. Well, if you say, and I'm not going to be using like exactly what's in there or anything, just generally. So if Congress often will pass a law that says something like you can't pollute the water, and then a different agency has to interpret exactly what pollution is.
Right.
And that's somewhat removed from the democratic process now because it's in a group that is underneath in the executive branch, sure, but we don't see. Right. You told us how we can comment on it, but very few Americans take part in that unless it's happening right in their backyard, and oftentimes too little, too late.
Right.
So the thought would almost be, should Congress not be passing a law unless it is directly includes what they mean by pollution, or have to actually pass a law for each pollutant?
Right. And this is exactly it. This is a huge subject that's open for debate today, which is this issue, and then how much deference should be given to the agencies in terms of how to deal with this. How much leeway do they get in making those interpretations? And that's part of what the Supreme Court was talking about in West Virginia versus EPA. The issue is people can get involved, and you're of course you are correct insofar as people have to live their lives. This is why they have representatives. This is why they elect people to Congress. But the reality is that so the reality is that they just don't have the time to get involved, but they really need to. And regulations are better as a result of when people get involved. But I'll give you an example of how this can sort of be run amok. I'll be real quick about this. I want you to, there's something called the incidental fallback rule. Yeah, or at least it was. Thankfully it's gone now. But I want you all to imagine a plate of French fries. Now that plate of French fries represents the soil underneath, the bed of a river or stream or pond or whatever. And under the Clean Water Act, it was perfectly legal for you to scoop up the bottom of that stream. And so picture it, you pick up a bunch of French fries from the plate of French fries. If any of those French fries fall back onto the plate, that would be considered pollution, right? It's the same stuff from the bottom that you just picked up, but because it falls back, it's considered pollution. It's called the incidental fallback rule. And that was hugely problematic. It would have made it impossible. It makes it impossible for people to engage in activities in rivers and streams and wetlands and whatever, because you have to make sure that nothing ever falls back from whatever you're scooping out. Whether and it should have been left to Congress to decide that that is pollution. Anyway, the point is that the more vague, and I guess what I'm saying is that even if it isn't so vague, the agencies are going to try to open those up to interpretation. And it's at that point that Congress really does need to step in and say something about it. And so many different instances in which that has happened, that's been called for.
Thank you.
Thanks.
I'm gonna change pace a little bit, and I kind of just want to hear your thoughts about something a little less of a question, more of a inquiry.
Okay.
The president being our commander in chief, having full control of our military, that was written in a time when, we had George Washington, and every really most important men in society were part of the military. It was a big role in everyone's life. It was a general concept. And, now you look at our presidents, and there's so little closeness to to touching the military. I think that the last one that was part of the military was Bush Jr. And then before that, I really don't know. So I just kind of want to know, like, do you think that that's something that should be looked at? Because how can you control something? How can you control something well that you really just have no true idea about?
Well, it's funny because I think that's actually something more pervasive even outside of the military. And I'll get to the military question in a second. But one of the things that I had recommended for a very long time was that bureaucrats, civil servants, I should say, I don't want to be, I don't want to, be insulting to them. But, civil servants should spend some time walking in a mile of a regulated entity's shoes, a small business owner's shoes. And so I had proposed that once a year, while they're doing other kinds of training, and civil servants do all kinds of training during a year, that maybe they be given a fake, hypothetical small business, and they would have to go and look up they would have an hour to figure out however many regulations that business had to comply with, just to get a sense as to what these small business owners are dealing with. What you're really talking about here, it's almost akin to, and not that I want to again denigrate this, but it's akin to what a lot of directors will do when they're filming a war movie and they want their actors to understand a little bit about this, so they'll send them to boot camp for a bit. I think there is a problem insofar as a lack of military experience with civilian officials who were in charge of the military. But that being said, that's part of why the founders wanted it that way. They did not want the military to be a whole separate entity. The two essays that I'm writing this week for Constituting America have to do with Stalin and the tight control that Stalin had over his military. And they were all they all had military backgrounds. What we did not want was a situation where the military could be an entity unto itself. We want that check of power. That's why you have a civilian commander in chief, and at the same time, Congress being, having the purse strings and being only able to declare war. But you're absolutely correct in that our leaders, and I would say not just the executive branch, but members of Congress as well, need to have a better understanding as to what's going on here, because they are turning our military. I'm lots of different people are using our military for experimentation. And again, I don't want to get political, but there are plans and programs within the military that I believe undercut the military's effectiveness. And I think if they had a better, and I say this, by the way, as someone, in the interest of disclosure, I am the dependent of a military retiree. My wife was an officer in the Air Force for 25 years, so I have that connection there. It's a good question, though.
Thank you. I think we got to pass it for some audience questions now.
Yeah, we got a couple of minutes.
Well, thank you, Jewel and Jorn. And Andrew, we've got two questions on Title IX. I'm going to try to put them together if I can. Sandy
Sure.
Thatcher and James Klinger both ask about it. And Sandy says, the Obama administration issued a letter about enforcing Title IX, which colleges generally followed. Then the Trump administration went through the entire administrative procedures process to give its interpretation stronger legal grounding. The Biden administration is going through that process now, already having issued an executive order, more or less, advising against following the Trump procedures. But now I think also Department of Education just issued an actual rule, a regulation that's actually in a comment period right now.
Yes.
And Sandy asks, in practice, how much difference does it make if colleges follow the current administration's interpretation, whether it has gone through the entire process or not? And then Professor Klinger kind of adds on with that, as making the comment that it was important that the Department of Education replace the guidance of Catherine Lehman on Title IX with a regulation so that it can go through the notice and comment period. So what are your comments on?
Well, so listen, I don't claim to be an expert in Title IX at all. I will say this much, right? It's a situation in which the Obama administration, it gets into what we've been talking about. The Obama administration issued an interpretation letter, and essentially because the Department of Education holds so much power over these universities, essentially, the universities, and I think frankly most of them wanted to go along with what the Obama administration was saying in this interpretation letter, but some did not. So they issued this. Then the Trump administration comes in, and they do exactly what's supposed to be done, which is you want to codify it and make it more difficult for it to be changed down the road. Then you go through the APA notice and comment rulemaking process. And, part of the problem, of course, is that you have institutions of higher learning that wanted to do it the way that it was before. They were in many ways openly hostile to the Department of Education in that administration. And so, President Biden comes in, and he again, then because what they did under the Trump administration went through the notice and comment process, it necessitated the Biden administration going through that notice and comment process, which is a difficult process. And yeah, I think you're right. I think it is open for comment right now. If you are at all concerned, send in your comments, and frankly, send in comments, whether or not they can be fleshed out on their substantive. And there may be organizations out there that have created model comments that you can, I'm going to use the phrase gin off of or build off of, use them, or at least just send in and say, I support the regulations as they were before. That's important. It is important to have your voice heard. And let me explain why real quick. I'm sorry, Kathy. Postcard comments don't mean anything from the substantive perspective, right? In terms of being able to challenge the rule. But invariably, when a regulation is because remember, all of these agencies have oversight by relevant committees in Congress. And when Congress is looking into rulemakings and folks are coming into congressional offices to talk about those rulemakings, invariably they will ask how many people commented on them and on which sides those comments fell and what kinds of comments that were being made. So one of the effective things that NFIB used to do, incidentally, was that they could distill down in terms of their polling, they could identify by congressional district where these comments were coming from. And that was very important for members of Congress to figure out. So if you have participated in this, it's important, members of Congress will find that important as they are also looking at these issues. So as I said, again, Title IX is not my area of expertise. It is a hot button, hotly contested issue. But then again, to get back to the earlier questions, one wonders what the real role of the federal government is and ought to be in any of this, especially when it comes to determining things like, collegiate sports or how colleges and universities, deal with the issues of men and women.
Well, and thank you, Andrew. You're right at the top of the hour. I want to give a shout out to someone in our audience today, Nick Henniger, who is one of our We the Future contest winners for Best College STEM. I think Nick has been on every one of our episodes so far. Awesome. On Countdown to Constitution Day. And I know we've got some other audience members. If you've been on every one of the episodes so far and you're in the audience and you're still with us, raise your hand. There's a raise hand thing. I'd love to see it, because we're offering everybody who watches all of our Countdown to Constitution Day episodes a certificate of constitutional knowledge. And we are going to send those out. If you can't be on one live, you can watch them on the archives, and we will be on the honor system for that. So you can email us and let us know when this series concludes, and we'll get you your certificate. And look at this. We got a lot of hands raised. We are really proud of all of y'all for being on all of these so far. We've got Mary Margaret Balata, Kristen Bierman, Julia Agosto, Robert Spiegler, Karen Sue Hensley, Robert McKeeman. So thank y'all for being on all these episodes. I know my dad has been on them all. Don Hay, he hasn't raised his hand yet, but anyway, we look forward to getting y'all your certificates as this concludes, and come back next week. We're going to be talking about executive orders with Kara Rollins as part 2 of Article 2. So thank you. And Jewel and Jorn, any parting words you want to give?
Nope, just thank you for all of your scholarship.
Thank you. Thank you, Andrew. And we do encourage you all to visit. And Andrew, tell us one more time the name of your organization. We put it in the Q&A.
Institute for Liberty, which is iChooseLiberty.org. Institute for Regulatory Analysis and Engagement, which is Institute for Reg Analysis. And then check out the podcast, Andrew and Jerry Save the World. Just go and Google Andrew and Jerry Save the World. We had a great episode last week. Andrew and Jerry catch up, because Jerry and I hadn't done one in a couple of weeks. Our episode with Matt Schlapp a few weeks ago was fantastic. So go, please check it out.
Thank you. Thank you for all you do to help Constituting America. We're very grateful.
Take care.
Thank you all. Thank you, Aubrey. Y'all have a great week.